Well, let's take a look at other news making headlines today. An Optimum coal mine has filed a case against the Financial Intelligence Center Director Murray Mitchell. The case pertains to the FIC Director providing a list of so-called dubious transactions to the Minister of Finance, Gordon. Optimun claims that FIC Director's decision to issue the certificate was irregular, unlawful and liable for review. Optimum seeks to have the certificate set aside. Optimum has cited several reasons against FIC Director's move to offer the transaction details to the Minister of Finance. Optimum says issuing FIC certificate to Gordon was irregular, unlawful, liable to be set aside. Optimum suffered significant reputational harm as a result of the release. Transactions reported in respect of it and its rehabilitation trust are in fact entirely lawful. Optimum seeks details of impunged transactions that relate to it and Optimum Rehabilitation Trust. Details must be provided to Optimum to investigate and account for those transactions. Well, to discuss this further, we're now joined by political analyst Tshepo Kgadima. Good afternoon to you and thank you for joining us here on ANN7. Firstly, Optimum has filed a case against the Financial Intelligence Center Director Murray Mitchell. This relates to the certificate issued to the Minister of Finance, Gordon, which Optimum argues is irregular. What exactly is your response and your comments with regards to this action?
I think this course of action that is now being pursued by Optimum Coal Holdings in the courts against Financial Intelligence Center is to be welcomed because it adds to enhancing of jurisprudence in South Africa. And at the same time, I think many people have commented and asked why Oak Bay-related companies had not been seeking redress before the courts. What we are seeing now is a different turn of events, but I think very much welcome, because the courts are the ultimate arbiter in all disputes, and they are the correct forum whereby questions such as these ones and transgressions against the constitutional rights of citizens, the courts are the correct platform to be able to deal with such.
Mr. Kgadima, in your opinion, where did the FIC err if they did indeed err?
We must bear in mind that Financial Intelligence Center is actually an organ of statute, and that statute being the Financial Intelligence Center Act of 2001, which came into effect in 2003. And it is solely under that act that we have to read into the role and the purpose and the functions of FIC. So when one looks at the certificate that was issued by Financial Intelligence Center to Mr. Gordon, you can clearly see that when you read the act, clearly there was no lawful basis upon which such certificate could have been given to. And also it is important to know that it is still a purported certificate because there are no details as to what it actually is being certified in that so-called certificate.
But what are the chances of this application actually being successful?
Look, I mean, I haven't seen the papers that Optimum has filed in court, but on the really on face value, when one looks at the FIC Act of 2001, I cannot see how they will not be able to hold courts. We have to bear in mind that the so-called certificate is actually fundamental to the course of action that has been pursued by Mr. Gordon in his application for a declarata in court that he cannot interfere. That FIC certificate is fundamental to his cause. The issue then becomes, well, under what basis was such certificate issued? And it will be important to see how the courts look at it. I believe that the courts need to be jurists. They are not politicians. They are not propagandists. And they need to do their functions. And that is ensuring that the rule of law holds. And if they were to really apply the rule of law, I would be surprised if they would rule against the relief that Optimum Coal Holdings is seeking.